persons will be determined, Mr. Speaker, by the parole board, which will be a creation of statute, and this board will be empowered by legislation to impose electronic monitoring on parolees in appropriate cases. Clause 12 provides for the type of electronic monitoring device to be fitted on a person or respondent. In making such a determination, the court shall take into account the recommendation of the electronic monitoring manager as well as the list of approved devices stipulated by the minister under Clause 8. Clause 13, Mr. Speaker, would empower the court to request that the person or respondent who is to be fitted with an electronic monitoring device make full or partial payment for the use of that device. The court's power would be exercisable on the basis of the report of the electronic monitoring manager. Mr. Speaker, this is the position in Canada, in the United States, and in Australia, and soon to be in Trinidad and Tobago. The People's Partnership Government, our government, is an all-inclusive government. It does not discriminate, especially on the basis of poverty and youth. And in this regard, offenders who are unable to pay will not be disqualified from participation in the program. Our government will not indiscriminately send such impecunious offenders to prison. Clause 14 would provide for the terms of electronic monitoring. Mr. Speaker, the interference with an individual's liberty is a grave step which is not to be taken lightly. This legislation has a number of built-in safeguards. For instance, the court has sole discretion to determine how onerous the conditions of electronic monitoring will be and the period for which the device will be worn. I repeat that this is not a government imposition. Our government is introducing a legislative framework with which the judiciary, the courts of this land, as well as the parole board, when it comes in shortly, Mr. Speaker, once we are favored with the support of this honorable House. So the court, it is the court and not courts. Don't mix them up. It is the court that has sole discretion to determine how onerous the conditions of electronic monitoring will be and the period for which the device will be worn. The court will make a decision to impose electronic monitoring on a person or respondent, which shall include a home detention, inclusion or exclusion requirement restraining such party from being present in a specified place for a period of time. Mr. Speaker, the primary purpose of electronic monitoring, which is not an electronic monitoring mechanism that provides the kind of echoes that I am hearing in the House, is to monitor compliance with the aforementioned requirements, to ensure that the persons to whom it applies do not enter proscribed areas or contact prohibited individuals, and to safeguard the public and prevent reoffending. If a person is placed on electronic monitoring and they don't want you to go by the Queen's Park Savannah, from the time you reach within 100 yards of the Queen's Park Savannah, a loud sound will go off on you, Mr. Speaker. You will be so ashamed that you will go straight back where you were. And if you don't, before you reach the 100, before you reach the Savannah, the police will be standing up there waiting for you. Such is this effect, Mr. Speaker, of this facility. Part 4 of the bill comprises clause 15 through 20 and would set out the offences which might be committed by a person, respondent or other individual under the proposed legislation. Under clause 15, a person or respondent who deliberately tampers with a device or who aids or abets the tampering with a device commits an offence and is liable on summary conviction to a fine of $100,000 and to imprisonment for 2 years. So, Mr. Speaker, if you have 2 years to go on a 6-year sentence and you're released on electronic monitoring and you only look to tamper with that or get somebody to help you to try and take it off, not only will you be found still trying to take it off and locked up, but you'll have to do a further 2 years imprisonment for interfering with it. So, Mr. Speaker, this technology is quite expensive, and public safety is also paramount. In this regard, anyone who compromises its integrity must incur the full brunt of the law. Clause 16 would set out the procedure to be complied with where a person or respondent fails to comply with a court decision or breaches any agreement or condition related to the use of the electronic monitoring device. Clause 17 would empower the court, I repeat, the court, in cases of non-compliance or breach, to impose the original sentence which would have been imposed on the person, as well as to impose the penalty prescribed for breach of the protection order under the Domestic Violence Act. This clause will also provide a defense to tampering if it can be proved that the tampering was done in circumstances which constituted an emergency. So a defense is provided to you if the circumstances in which you seek to tamper is an emergency one. Part 5 of the bill comprises clauses 21 to 23 and provides for miscellaneous matters which relate to the procedures to be followed by the staff of the electronic monitoring unit. Mr. Speaker and members present, I wish to reiterate that this bill aims to improve the current system of pre-trial and post-trial supervision and monitoring of offenders. The fundamental content of the legislation provides for the introduction of the use of various electronic monitoring devices as determined by the courts in their sentencing and supervision options. Electronic monitoring is not intended to replace traditional means of supervising offenders on release, but represents an additional monitoring tool, allowing parole and probation officers to analyze data received from tracking devices and to ascertain whether or not offenders are acting consistent with their parole or probation conditions. Further, in an attempt to remain compliant with international obligations, namely the 12th United Nations Congress on Crime Prevention and Criminal Justice Declaration on Comprehensive Strategies for Global Challenges, our government has acknowledged the value of electronic monitoring as a crime-fighting initiative. Mr. Speaker, electronic monitoring offers benefits to participants of the program. In that, and I count them among others, 1, it provides the opportunity to maintain employment, attend treatment, and to keep the family unit intact. This is so important, so very important. When a man gets locked up, By the time he comes out, his wife is gone with some other man. His children are all over the street. It happens. It's no laughing matter. You know, women don't have the comfort of their husbands. But if she knows that her husband is coming out, even with an electronic device on his leg, she will take him any day with the device on his leg than have him locked up in the prison. Because rest assured, many of them, and it's all the experts will tell you, after a little while, the wife gone and the children on the street. By the time he comes out, the wife has children for somebody else and dies yet. I know that. I have been in practice. I've been there as a judge for 17 years, and before that about 15 years as a lawyer. I speak from experience. I know what I'm talking about. And the national communities knows very well what I'm talking about. So why are we going to deny it? Don't be in denial, member of Port of Spain South. Don't be in denial.
It promotes family life.
It promotes family life. It teaches the offender how to plan and how to schedule his or her activities using behavior modification techniques. It affords the defendant on bail, while awaiting trial, an opportunity to maintain employment, keep his family intact, assist in the preparation of his defense, and avoid unnecessary pre-trial incarceration. It acts as a post-sentence sanction by allowing the offender, Mr. Speaker, to obtain or maintain employment, engage in treatment, and pay restitution to the victim of the crime and to the community. Mr. Speaker, for those who may have concerns about the appointment and the status of the Office of Electronic Manager, let me say that we have looked at the bill even more closely since it was laid. And we propose that on the floor, at the appropriate time, that we create additionally the position of Deputy Electronic Monitoring Manager, that these offices shall be public offices to which Section 121 of the Constitution shall apply, and shall also be prescribed offices for the purpose of Section 141. However, Mr. Speaker, we also seek to include a new subsection that without prejudice to the power of the Public Service Commission to make an appointment to the Office of the Electronic Monitoring Manager, where prior to the making of the first appointment, after the Act comes into operation, the exigencies of service require an officer to perform functions relating to that office, the ministry may engage an officer on contract in order to secure the interests of the unit. So, Mr. Speaker, what else can I say? I think that I have said all that I could reasonably speak of in order to whet the appetite of the members opposite to rise for a moment during the course of the join us. We said we will rise. We have risen, and we now want to ask you to rise at the appropriate time and join with us and pass a progressive piece of legislation in this House. Mr. Speaker, I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to make provision